And welcome, folks. It is January 31st, 2022. I'm here in the kitchen cooking up some intro to law with Professor Mike Dayton and a few topics that we want to bring to your attention this week. So, your first group assignment is due on Thursday, and that's the Serial 1 assignment. All right. It's important that you get in touch with your group, and we've got a lot of questions. How do I get in touch with my group? Thankfully, we foresaw that. We cooked up a little tasty module for you, and it's 0.3 group work info. All right. So there are such topics in there as how do I view my groups as a student to see who's in your group? How do I message my group members? And how do I start a group discussion? So go ahead and go in there, read all of those, as well as the tips and policies on group work, which explains hiring and firing, disciplining of group members, which we hope you don't have to do. But before you contact us about, like, oh, my group member isn't responding, or, make sure you read through all those. I don't have the power to make your group members respond. There are 600 plus people in the class. People do add and drop and sometimes stay on icon after they've dropped the class through the registrar's system. So the person you're, trying to contact may not even be in the class. If somebody does not respond or is not reachable, you simply note that on the assignment and they won't get points for the assignment. So that's how we guard against the free rider problem. All right. So note that directly on the assignment. Don't email us and tell us to get them in line, because we don't have that kind of power. We can't make them come in the kitchen with us here. Okay. It's a purely virtual kitchen. This week, before I get into the course material this week, you may have noticed there was some news that Supreme Court Justice Breyer is going to retire by the end of this term. And so President Biden will have the opportunity to appoint a new Supreme Court justice subject to Senate confirmation. I recommend SCOTUS blog for a source of news and information about the Supreme Court in general. It's a very good, non-political, right down the middle blog with news and analysis. So if you're interested in who might be in the running for that and what that path looks like, I would recommend SCOTUS blog. And then in class this week, we will continue the American court system. I did hear from some of you guys that the audio was bad on my last lecture. I think I had the microphone a little too close to my mask, so I'll change that next time. And I have another video I can sub in from a different section. Also, you can always look at the pre-recorded videos, which were from just a couple years ago. Not much has changed about the American court system in that time. So you'll have that. And then we get into alternative dispute resolution, which is a way to settle your differences legally without litigation. So Professor Dayton, you mentioned that. Now, I've never done an arbitration. I've never been involved in one from any side, plaintiff or defendant. But you mentioned that some of your clients use arbitration clauses. Can you speak to that?
Sure. And you'll see in your materials, you see mediation too. I mean, that's another thing where basically, couple parties get together, and it doesn't have to be binding. You just kind of get a third party in there to help you talk through things. But in arbitration, it really is intended to be kind of a replacement for the court system. So instead of filing with the court, and since what I do is commercial stuff, as opposed to criminal law or family law, that sort of thing, it can be a couple years before your case gets heard, because those other things take, they're more important. They take precedent. You can basically hire kind of the judges, hire the arbitrators between the two parties, and it's still an advocated system. But you generally agree to have that be binding in the same way that a litigation case could be. And you get that judgment entered in the court, just like you would if the court decided the case. theoretically, if you do it right, it can be cheaper, take less time, and maybe even get better outcomes than the normal court system, simply because the court of first resort that you're going to get, they just don't see business type issues as much. It's just not what they do on a day-to-day basis. Um, there is an Iowa business court, so they've kind of tried to consolidate business cases in front of the same district judges, but really that's kind of a side gig for the district judges. They still are seeing the other stuff most of the time. So, which isn't to say I've heard very good things about the business court, and there are very good things about the court system, but some companies prefer arbitration for the reasons I mentioned, and because you can get confidentiality. Like, you can just say whatever happens here is going to be confidential, and so nobody knows kind of went on. So starting to see a lot more arbitration with my clients. Historically, you'll have seen it a lot in airplanes or really big companies, or things where people want to consolidate things and keep them confidential, or just kind of want the forum for them. You might get consumer type things might subject to arbitration. So that's what I'm seeing. No right or wrong answer, but good things to know about.
Yeah, that's so what you mentioned is about the expertise of the neutral who's hearing the case in either case. So with our district court bench, a lot of those lawyers come from all different backgrounds, prosecutors, legal aid, family law, juvenile law, a few from corporate law practice, but really very few, more from, I would say, the criminal justice side of the bar. And so they're very intelligent people who are picked through an excellent merit selection system, but they usually don't have much commercial law or business law background. We do have that business specialty court, but from what I've seen, and it's doing good work, but it's limited. There are a handful of judges. So with arbitration, you can hire someone with a specific expertise. So like one of our mentors, Lon Moeller, who we were TAs for in this class back in the day, he's an arbitrator in a lot of labor disputes. So like Ford or Chevy will hire him, in a dispute between the auto workers union and management. And he has that specific expertise and has done those cases before. So they know kind of what they're getting. And to your other point about the delay. So right now, filing a case in the Iowa district courts, you're probably looking at least 2 years before you get to court. And if there's a criminal or a family law case that has to be heard instead of yours, you will get bumped. And that is not great for business if you have to, whether you're on the plaintiff or defense side, if you have to enforce a non-compete against a former employee, if you have to bring suit because another company is stealing your trade secrets. 2 years is too long in the real world to wait to enforce those rights. So arbitration, may be a good remedy there. So very interesting stuff. Well, we hope you are doing well, staying safe and healthy. This week, follow along with the videos, get through modules 3 and 4. Your first serial assignment is due this week. You'll have another one due next week. And just be reading the Lingwall book and looking to the future here. And we'll be back at you next week with another update. All right, folks, have a great week. We'll see you next week.